Any mention?
But I beg to make a mention of item 6 of the hearing list, my lord. It is kindly listed after 3 weeks. Or
It's not yet settled. Nothing.
my lord, some process is still on.
Any likelihood?
My lord, we are.
How much time you?
I'm praying for 3 weeks. My lord.
No objection, Your Worship.
On prayer of the petitioner, not objected to by the on prayer made not objected by the running authority. List after 3 weeks. Yes. Just see if something happens.
My lord.
Oblige.
Oblige.
May I please, Your Lordship? I beg to mention item number 23, Lordship. 23.
Yes.
Yes, Lordship. After some time, Lordship. 2 weeks, Lordship.
My lord.
On prayer made by the petitioner, list after 2 weeks.
Similar prayer for item number 16 also, Lordship.
Who is the other side in 16?
There, that's it, Lordship. 16.
Who is the other side? 16.
Your Lordship, I'm appearing for the item number 16 for the sole respondent, Your Lordship. Sole respondent, Your Lordship.
Yes. You
No
have any
Your
objection?
Lordship. No objection, Your Lordship.
Yes.
After 2 weeks, yes.
16 also same order.
Highly blessed,
On
Lordship.
the request of the petitioner. Yes.
Your Lordship, I beg to make a mention of item number 12, 13, and 14, Your Lordship.
These are all connected matters.
Yes, Your Lordship.
Yes.
After 3 weeks, Your Lordship.
12,040 on prayer made by list of 2 weeks. Yes.
May I please, Your Lordship?
Yes.
I'd like to mention item number 7. Kindly have this matter for 2 weeks, Your Lordship.
And for the respondent number 7, Your Lordship.
Why after 2 weeks?
The arguing counsel is on parhood matter, Your Lordship, for the division bench.
Your what?
Respondent number 7.
How many respondents are there? This is what? This is regarding what? This is matter
Parity of
relating
pay, Your Lordship. Parity of pay.
parity.
Yes, Lordship.
There are some private respondents also.
Yes, Lordship.
No objection. Just one prayer of the petitioner, not object to the respondents. List after 2 weeks.
2 weeks, Your Lordship.
Okay.
Oblige.
Oblige.
My lord,
Yes.
I beg to mention item number 10, my lord. 10. I'm saying if this matter can be taken up after 2 weeks, my lord.
Service matter.
My lord, this is service matter. Cancellation of appointment, my lord.
Okay. 2 weeks. This is a request to the petitioner. Yes.
My lord, the similar prayer for item number 17 as well, my lord.
Item 17. Who is the other side?
I'm there.
Any objection?
No, no, man.
Okay. Same order. 17. Yes.
Your Lordship,
17?
like,
Wait. 17 is your legal aid counsel.
My lord, this is regarding the quashing of proxy.
Yes.
Your Lordship, I beg to mention item number 22. The senior counsel is unable to present the case today. I pray for 2 weeks' time.
Here, appearing for which respondent?
3. Respondent number 3.
This one number 3. Here, appearing on behalf of Mr. Mahanta, SP Mahanta.
Yes.
No objection.
Yes. Just made on behalf of this one number, sir. Yes, sir. After 2 weeks. 2 weeks. Wait. Yes.
Much obliged.
May it please, Lordship, I beg to mention item 15, Lordship. I'm praying for 2 weeks' time, Lordship.
Yes.
No objection, Lordship.
15 also. 2 weeks. Prayer of the petition. Yes.
May it please, Your Lordship. Your Lordship, I beg to mention item number 24. I pray for 2 weeks' time, Your Lordship.
No objection.
And prayer made on behalf of the appellant. List after 2 weeks. Yes.
Highly obliged.
May I please, Your Lordship, I beg to mention item number 19. I pray that this matter will come after 2 weeks, since the senior counsel is having heard matter in court too.
No objection, Your Lordship.
Same order. Prayer. Appellant. You are making.
Appellant.
Yes.
Lordship. No objection.
Which one?
No objection, Your Lordship.
All right. You have taken note.
Obliged, Lordship.
May I please, Lordship, I mention item number 8 and 9 of the hearing.
Joint request.
Joint request, Lordship.
When do you want it?
After 2 weeks.
After 2 weeks, yes.
And joint request made by the parties. District attorneys. Yes. 8 to 9. Yes. Highly obliged.
May it please your Lordship? Lordship, I beg to mention item number 20. Your Lordship, the matter is pending before DB. Kindly allow 3 weeks of time. Respondent number 3.
Item 20.
Yes, Your Lordship.
You are making a mention on behalf of the.
Respondent number 3, Your Lordship.
Yes.
I'm for the petitioner, my lord.
This
This is a POXO matter, my lord, where they are seeking
gentleman.
quashing.
It's before continue.
Yes.
We will have it after. When?
3 weeks, Your Lordship.
3 weeks. Please also 3 weeks. Yes.
Highly obliged, Your Lordship.
Lord, item 2 of the hearing list, my lord. I've been.
Item?
2 of the hearing list, my lord.
Item 2 of the. Yes.
Mr. James, thank you, is appearing in this case, my lord. He has some personal difficulty. Requested me to make a mention on his behalf.
Please, Your Lordship,
This
I'm
is for the petitioner.
appearing for
Lord.
respondent number 4.
And
No
GHADC is also.
No, Your Lordship, yes. But I'm appearing for the private respondent.
Yes. No objection.
No objection.
This is what?
Your Lordship.
Nakmashik dispute.
Your Lordship, regarding Aking land, there's a
The
dispute
land
of...
dispute between 2 Akings.
Your Lordship, dispute of boundary.
No interim order in this.
Your Lordship.
Okay. Just say.
After 2 weeks, my lord.
Mr. Thappa, Rani Council. Appearing on behalf of Mr. James Sheen. Thank you, Rani Council, for the petitioners. Please for adjournment of the matter on the ground of personal difficulty of the Learned Council for the petitioner. Stop. We do not know what about the district council. District council is not here. You will inform them.
We'll inform you.
We'll just say the Learned Council appearing with the respondent is no objection. Prayer allowed. List after 2 weeks. Yes.
Obliged.
Yes.
Please, Lordship. Lordship, I beg to mention item number 3. Item number 3, Lordship.
Item number 3.
Lordship. Lordship, 2 weeks.
Yes, my lord. No objection. On prayer made on behalf of this respondent, not objected to by the Learned Council of the petitioner. List of 2 weeks. Yes.
Obliged, Lordship.
Supplementary cause list, item number 1.
May I please, Your Lordship? I beg to mention item number 5 as the conducting counsel is indisposed, Your Lordship.
Item number 5.
Yes, Your Lordship.
Yes.
Mr. Essen. Mr. Essen is indisposed, Your Lordship.
Mr. Shen is for
The state.
the state respondents. Yes, who is for the petitioner here? Who is for the petitioner? Just wait. Let us see what happens. Just wait.
Supplementary cause list.
Yes.
May I please, Lordship?
Yes. Yes.
Maintain appearance for respondent number 2 and 3.
2, 3.
On behalf of Mr.
On behalf of Mr.
P.R. Paske.
You have to appear on behalf of the respondent, isn't it? You are not supposed. Paske is not a party here, Mr. Paske.
You'll be filing our power, Your Lordship.
So you file your power. We'll just say you have entered appearance. Okay. And then you'll seek instruction. Okay. Just say, Mr. Okay, so say. Please tell your name again, please. Okay. Sorry, I forgot. Yes, MSc Dakar, London Council present over the petitioner. Mr. Kharmi, London Additional Senior J is present on behalf of the state respondents. Mr. Misha has entered appearance on behalf of the number 2 and 3. And place for some time to obtain an instruction. Prayer allowed, list after 2 weeks.
Hearing item number 4.
Yes.
Lordship, Mr. Paul is on legs. Lordship, I'm praying if the matter may come up at the end of the board.
Well, we have raised a point of maintainability because, my lord, they have come against the order and judgment which has been passed in the first appeal, my lord. But they have come by way of civil revision. This is a suit filed by the presiding officer, subordinate this country court, my lord, by the petitioner. Thereafter, my lord, the suit was decreed in their favor. After that, I had filed a first appeal, my lord. That thing was overturned in the first appeal, my lord.
Appellate court reverse. Appellate court reverse.
So they have come before this honorable court, my lord, by way of civil revision, my lord.
Under Rule 6.
Under Rule 6, my lord. So that's the initial point, my lord, if they can. Thereafter, my lord.
Your Lordship, if they're raising maintainability, they can start, Your Lordship. Mr. Paul, come on.
He has already started. He said that you cannot. Isn't it? This Rule 6 in perimeter with 115. Anyway, since. Yes, Mr. Thapa, you're ready?
They had raised the objection with regard to maintainability, my lord,
That's what the court is
saying that it is a second appeal. But, my lord, your lordship is aware that in order to bring it within the realms of section 100, my lord, there has to be a substantial question of law involved. But here there is none. Therefore, my lord, and moreover, this revision is filed under Order 6 of the High Court rules, my lord. Per se, that bar would not apply insofar as Order 6 is concerned.
No, what about the judgment of our High Court in the division bench?
my lord.
That acting scheme of Millen, probably, isn't it?
Well, Komerchan judgment, is it?
No.
That's the acting scheme of Millen, the division bench judgment. With regard to Rule 6,
Rule 6.
I'm sorry, my
and Rule
lord, I'm not
36
aware of.
the Administration of Justice and Section 115 CPC.
My lord.
I've not examined that aspect.
Probably Mr. Karim's
My lord had appeared in the other
objection is on that,
My lord.
on the basis of that.
My lord.
But then will it bar them from filing it? Probably it merely speaks about the scope.
But even then, my lord, since the
They have to confine themselves to the jurisdictional area. So per se, we cannot say that this is not maintainable. It may be maintainable, but the scope will be limited.
limit,
You have to argue only on the question of jurisdictional error, nothing else.
my lord. But the suit has been filed by them only, my lord.
Well, I will have to examine that judgment, my lord. I'm sorry today.
You see, but then the probably you see it's nothing. Probably you see your scope will be limited. Okay, of course this is the otherwise also you have already this matter has come up from first appeal.
First appeal, no.
So cannot be something like a reappreciation of evidence against.
Right.
You see, even if you go by the spirit of second appeal, it has to be on the question of law only.
Right.
In such a case, the question of law has to be formulated first, then only. Or otherwise, 115, we will have only That is
Limited
what
scope.
perhaps Mr. Karim is saying. So you have to limit yourself to the jurisdictional aspect, nothing else.
My lord.
You just see that thing,
Well,
and then when can
Can have it after 2 weeks, my lord. In the meantime, I'll go through the judgment, my lord.
say on it?
you have come only under order 6.
Order
madam.
6, my lord.
Yes, this is okay. But then Rule 6.
Well,
If you go by the, of course, this court, subject to what you say, if you go by the judgment of our High Court, it has to be totally within the scope and number of 115, because that is what our High Court says. Because it originated from a single judgment of Justice Bhai Pai. Yes. That is
so
what.
it's
Yes.
after 2 weeks. madam, that's it.
Say, Mr. Tapal, Honour Counsel. Praise for urgent matter by 2 weeks to carry on Honour Counsel. If the respondent has no objection, to allot list of 2 weeks. Yes.
Obliged.
Item number 5.
Yes.
Please, Your Lordship. Usually the petitioner appears through VC, Your Lordship.
Nobody is there. On the last occasion also non-appears. 2 non-appears matters gets dismissed here in this court. None appears for the petitioner. MS, you are
SKH Nongrom, Your Lordship.
are you a GA?
Yes, Your Lordship.
Okay. MS Longman, Brown GA appears for the state respondent. Here paragraph. There is no representation on behalf of the petitioner on last occasion also there was no appearance on behalf of the petitioner. It appears that the petitioner has no interest to pursue the matter. The petition as such is dismissed for default. I just said petition is dismissed for default. Yes.
11.
Yes.
Mr. Bora is appearing in person here.
Has he been seen here around?
I met him in the morning.
It's almost afternoon now. You are 10 minutes to 12. Yeah, anyway, just let's say have it on some other day. Yes. No appearance for the petitioners. Just see.
He's here. He probably had.
It cannot be something like that, Mr.
I had a matter in the other court here.
You should inform somebody. Somebody should tell the court.
I have got the petition here.
Yes, it was Jagat Brahma. Oh, Hitesh Burma, who filed the application, isn't it?
It is Brahma. And the vehicle was also released to.
The order says vehicle was released to Jagat Brahma.
Is it?
Firmanama says
has the name of Hitesh Brahma.
it was released to Hitesh Brahma after due verification of the
Is it?
registration certificates.
So your contention is not correct then. Where is the Jumanaman? Okay. And where is the order of the court? Which says release the vehicle?
The order is at page 42 of the revision petition.
Yes, it is this thing. Hitesh Brahma.
This appears to be a typographical error.
Where? In the order of the court.
Yes, in the order of the court. Order
How
dated
can it be?
8/5/23.
This is needed to be corrected. It is only the court's order which is implemented, isn't it? Even Jimanama also is executed for order of the court.
And only this part of the order, seen and peruse as Zimma application number so and so. File
Which,
by
what is that
so and so.
page?
Page 42.
Order dated 8/5.
The opening lines of the order.
Yes.
And then the operative part of the order says that in view thereof, so and so is released on Zimma to the petitioner. Now the petitioner, as per the cause title in the petition, is Hitesh Brahma.
Yes, Mr. Bora.
My lord, the technical mistake is that as per the order, the vehicle has been released on Jimma to Jagat Brahma.
No, it has
not
been
to-
released. It has been released to.
Hitesh Brahma.
Page
registered
42.
That is the Jimanama.
Seen, perused, Jimma application number so and so, filed by petitioner Sri Jagat
We
Brahma.
have seen it. You see this Jimanama. You show him this copy and then pass it.
Petition, I have got a copy. That's okay, but the order is
Then why
wrong.
you, if you have a copy,
Now,
return to her. If you
now
have
second point, my lord, is petition under 457.
Yes.
Now, the case itself is with regard to the vehicle. It's not that the vehicle was used for some other case and that's why the vehicle was seized. The vehicle itself is the subject matter of the case.
Yes.
Now, I have paid money for that vehicle.
That is what we do not know. How can this court will know? That is your assertion. We are in a revisional jurisdiction.
GP payment proves that I have paid the money. Now,
Can
the
this
court,
court take cognizance of those documents? Is it admissible here at this stage, those documents?
this is a payment
Have you
voucher.
filed any application before the trial court?
I didn't get the notice. I could have.
You should have claimed it. What is the question of getting notice or not? Make a.
No,
at least-
actually, I could not go now because that court doesn't have power to review its own order. That's why I have come to the High Court. Actually, what my prayer is that I need a chance to go.
No,
go
you
to
have
that court below.
never filed any objection before trial court also. Where is the question?
No, I never filed because I did not come to know that there was a petition for Jimma.
If you have paid money, that remains only an assertion. It is yet to be seen.
Now,
It is yet to be-
if I have paid money, my lord, I am the owner of the vehicle. Sales of Goods Act,
We do
Section
not know
19
whether you
says so.
paid- See, this is your assertion. We do not know whether you
No,
have
not my
paid-
assertion. Section 19 of the Sales of Goods Act says so.
Yes. What does it say?
I am the owner of the.
No, your assertion.
So I should have been given a.
Wait. Just listen to the query of the court first, then reply.
Yes, ma'am.
Just because you come and you assert that you have paid, we'll take this statement as truth. That requires no further proof, isn't it?
The vouchers are approved.
That is what the Sales of Good Act says.
Payment vouchers only, that I have paid the money.
We do not know whether these vouchers are genuine or not. How do you know it?
They have to be genuine. They are generated by the bank only.
And that is payment for what purpose? How do we know?
That's what I have given in that the case itself is
See, Mr.
regarding the vehicle that I have paid money
just
for.
remember, you are in a revisional jurisdiction. You are not appearing before a trial court.
That is true.
Yes.
My
So here you argue.
my grievance that
Your plea has to be a legal plea. Now, as of now till date, you cannot be termed as the owner of the vehicle. Okay. And do you want to say that this, if Jimma is granted by the trial court, it cannot be cancelled? The bar of 362 will apply. Do you want to say?
it can be cancelled, but I need a chance to go there now. Whether I am able to go and file a petition.
Have you filed any application?
Not
seeking
yet
cancellation?
filed
Then
because I have already come to the High Court, so I have not filed there.
that is what. And you are making some assertion which this court
Yes,
would hardly
within the-
have scope to go into all those things. You may say that yes, you have made a payment. But then if they refute that, then which way you decide it?
No, what my claim is that I am owner. I want a chance to go and make my submission in the court below. I need a direction for that because directly I cannot go due to the bar of Section 362 CRPC. So if I get a direction from the court, I can go and file a petition there.
Whether an order of Jimma can be cancelled by the court. Which
Yes, by the clause 2 of 457 says so.
So what does it say? What is the grounds?
Petition is under 457, clause 2 says so that there can be a claimer. Some claimant can go to the court and claim ownership.
So then why don't you go raise your claim there?
That's what I want the direction to go to the court below with my...
If law gives you that scope, why you are here then? You do not need a direction.
The very case is regarding the vehicle for which payment has been made.
We can understand, but then you see, like in
So the person who has paid
in a revisional
should be called to the
jurisdiction,
court.
see, Mr. Bora, if you come here and you say that I am a registered owner.
Not registered owner.
Wait. If you say, please listen, then we may entertain your plea. Because as per law, a registered owner is presumed to be owner.
That is true.
Then we can say that yes, the trial court could not have released it to somebody else without ascertaining any claim. Wait, we have not finished. Now your claim is on the basis of certain payments which you allege to have made. We do not know whether that your assertion is admitted by them or not. Now in a situation it will be very difficult for this court at this stage to hold and say that you are the owner of the vehicle. An order pass is
That's for the trial court actually.
So we cannot, even if you are able to show that you have paid the money, we cannot give a finding that you have become owner. Can we?
As per
Can in
section
this
19 of
application
Sales
this
of
court
Goods
say
Act,
that
I
you are the
become the
owner?
owner. As per Sales of Goods Act, section 19,
Yes, what does it say?
the goods has transferred to me already.
How, on what basis?
Because it says property passes when intended to pass. The property has passed to me because it was intended to pass by the advertisement and after the accepting of the payment.
So that is, once the intention is that passes. A shopkeeper selling his item, sitting in a shop.
Only thing left was Form 29, Form 30 was not signed and the vehicle was, physical possession of the vehicle was not given to me. All I need is a chance to go to the lower court and make my submissions there. I couldn't go directly because of the bar of 362. Where there is a contract for the sale of specific or ascertained goods, the property in them is transferred to the buyer at such time as the parties to the contract intend it to be transferred. It has happened. The section says
Read it again. The entire provision.
where there is a contract for the sale
Where
of
is the
a
contract? Where is the contract in your case?
in the there was a proposal through the Meghalaya
That
OLX.
is what your assertion
I
is.
accepted the proposal. That is
See,
the basic
if you say
basics of law.
contract-
Proposal and exception and then
This
contract.
man is not ready to listen. A contract must be an admitted contract, isn't it?
It can be
A
touched
contract,
also.
a contract, there must be.
We go to the shop and we give money and take goods. That is also a contract only.
No. This gets complete when your sale is complete. Whether your sale is complete.
Here the intention is complete. When he has
So you did
advertised,
not-
I have
You did not get the
I
product
have
by
paid.
yourself. You did not get the product.
Only that much is left. Physical handing over of the product is not.
See, there is no question. This could come in.
It sounds like he,
See, whatever
he
you said,
took the
this
money
could-
and ran away with the vehicle without giving the physical possession. All I need is to make my
Just show us
submissions
the
in the lower
illegality
court.
in this order. This show us the illegality in this order of the magistrate.
Firstly, the name, and secondly, that I was.
Name has been clarified
the
now.
thing is that the
Yes.
court ought to have known that the vehicle itself is the stolen good. It's not that the vehicle was used for some other crime. Then the registered
So
owner
do
is.
you want to say that stolen?
That itself is the stolen good.
Wait.
Because money is taken from me and he runs away with the vehicle.
So is there any law which said the stolen goods should not be released?
They have to be after the
Just
trial
show
is
us some
over.
law. Show us some law. This court doesn't know. Just tell us the stolen goods can be released.
Give me some time. I am not come prepared with the. Just 1 week.
You are not willing to first ascertain the question which is to be determined by this court. You are harping on the issue that you have paid the money. There is an offer by them. You have paid the money. Vehicle is stolen good. So you are the sole owner, nobody else has the claim. How do you know the story given by you is correct and the version of the other side is wrong? And sitting in this revisional jurisdiction.
That is why I would need a.
So that is why you should know the limitation and frame your argument.
The court below ought to have issued a notice to the person who has paid for that vehicle, because that is in the case record, the low court case record. The basic case is that some person paid money for that vehicle.
Give us some law to show that.
That's Section 19. That the property is mine. Section 19 of Sales of Goods Act.
You show us what is to be considered when a vehicle is to be registered. A vehicle which is a subject matter of the crime is to be released.
No, the thing is that the case is little different. The vehicle owner took money promising to give the vehicle. After taking money, he ran away with the vehicle.
Who is the vehicle
owner? Sounds like that.
Who is the vehicle owner?
The owner who, Hitesh Brahma. He himself.
You are representing Hitesh Verma? You have taken money from him, you admit?
No, even his,
Through agents, he has taken money.
his petition shows that the
you
money
are
is
now-
those are matters for
Now you
trial.
are taking a diversion. All along you are saying that he has taken money. Now say that through agent.
Definitely.
Can this court ascertain this fact?
money was paid to
That
one
is for
Mr.
the trial
Vinay
court.
Singh.
That is true. It's revision court
So
cannot.
if you
All
say-
I need
if
is
you
a
admit
chance
on
to go to
this-
the trial
If you
court.
admit on this, there is nothing this court.
And there is no infirmity in the order.
That is exactly what we can. We know.
Infirmity is that the name is wrong to whom it has been given, and secondly that I have not been given any
Anyway,
notice.
this
That
court
was
Since
clarified.
I have paid money for that, that
If
should
you
have
say
been
there is
there in
still
the
ground,
notice
you
of
may
the court
dispose
below.
of by saying these things. If you say name is wrong, you are because Yamanama says that it will be released to the person who has filed the application. So we do not see there is anything wrong.
Notice to
What
me, I want.
Mr. Gautam said that this appears to be a clerical error. This court accepts that.
I need a chance to go and file an application before the law
Under
court
what
regarding
law?
this.
Under what law? Just show us. You show us your entitlement.
Under clause 2 of 457, I can apply there. I
Show us.
can make a claim
Read
there.
it out. Is it correct? Is it correct?
No, this clearly appears to be a civil dispute, my lord. See,
Not a civil dispute. 457 clause 2 has
the vehicle is registered in someone's name. He
At
has
this
paid
stage,
money
when
to
somebody has
else.
paid the money and
now
vehicle
he
is
claims
registered
that
in
he has-
somebody's name, the real owner is not known. So clause 2 will come in of 457.
The vehicle was released after verification of the registered documents.
That is under clause 1.
Well, then here, class 2, we do not know. This may not apply at this stage now.
Clause 2 will not apply.
Now, because it has been released already.
It is already released and it was
It comes-
released to a registered owner.
Yes.
There is clause 1 now.
Unless
When
it is
there
otherwise
is-
shown.
When there are two persons. One has paid the money and the vehicle, one has got the registration in his name. So the actual owner is not known.
Well, transfer of ownership
So
of
then
a,
clause 2
of
will
a
come.
registered
Just show us
vehicle is
your money
complete
receipt. Show us your money receipt.
only after
Where you have transferred
form
money.
number-
Just a minute. Where you have paid money to Mr. Hitesh Verma. Just show us.
Not to Hitesh, through his agents.
That is good enough.
That is a matter of
good
trial.
enough to reject your application. That is good enough to reject your application. You will show us some law, or you want that matter to be disposed of now?
I want to, yes, I need some time.
We'll just give you one opportunity. You must understand the limit of it. You may have a different story, but then you cannot establish before this court. So, but then you are not ready to understand that this thing. Now, you give us supply as a Xerox copy, not a original copy of this application. Original you retain. You supply as a copy of that Xerox copy of a Jimana also. You find out some law
Yes, ma'am.
similar to your situation,
Yes, ma'am.
where you can say that the release of vehicle in such a case
Yes, ma'am.
is illegal. What has been done in this? So far as your contention with regard to the wrong name, which
That is technical, that can be corrected.
which was very
No.
appealing on your last argument, based on which this court had ordered production of this, appears to be only a clerical error, nothing else.
That is clerical.
Because we have perused the Jimanama and we are satisfied that vehicle has been released to Hitesh Verma. Now, only one thing is that if you can show us that you have made a payment to Hitesh Brahma, then we may see, we may be ready to hear you. But then if you cannot show it, then it becomes difficult.
Not to
Just
Hitesh,
because
but
somebody else, maybe a tout may come, he claimed to be Hitesh Sharma's agent and ask money from you.
he has shown the vehicle photographs.
That is, see, it is for you to be,
In his advertisement in the Meghalaya OLX. So seeing that advertisement only, I came to know that this is the vehicle for which I am paying. The person who is selling may not be the owner. Normally the owners don't sell. Like Bajaj company, the Bajaj does not come and sell the vehicle here. The agents sell it.
how do you say that he was responsible for that?
That is a matter for the trial to establish. Trial court.
Exactly. So if you understand that thing, how you are asserting your claim here?
But
You first
there is a
establish-
claim of two owners. One has paid money, one has got the RC. So the actual owner is unknown. So I have a right to.
You are not ready to understand that you have not made any direct payment to Mr. Gautam. You are not ready to understand. Anyway, just say.
Your Honor, but as far as the prayers in this instant revision is, the matter ends here. Because, Your Honor, kindly look at the prayer, page number 20.
What does it say?
Your Honor, this concerns the...
Read out.
In the above premises, the petitioner most humbly prays that your lordships may be pleased to call for and examine the records of the Sadar CS case number 167 of 2022 proceedings before the court of the Chief Judicial Magistrate Shillong for the purpose of satisfying thyself as to the correction, legality and propriety of the findings, order, recorded or passed, and as to the regularity of the proceedings before the court below with regards to the grant of Zimma.
To respondent 3 who is not a registered owner of the vehicle.
Well, that has been resolved. Further, to issue notice to the respondents to show cause upon
He has prayed for quashing of the impugn orders.
Yes, Your Honor.
Then, so it is nothing is over till now.
Yes.
So long the matter is not disposed of. We'll give him some more time.
Even the MV Act provides that how a registered vehicle is transferred from one owner to the other. That I believe is at section 50 of the MV Act. Now it speaks of two forms being executed and the same being presented before the district transport officer. Only thereafter the ownership of the vehicle is transferred. So in his case is that I have paid money to some.
I have some
That is
rulings
exactly the problem.
which I'll come
See,
next date
See, this court
on this.
would have accepted
Yes.
his submission to some extent if there was anything to show that he had made some direct payment to you. It is not that case. His contention is that he has paid to somebody agent who claimed to be, somebody who claimed to be your agent. So that is what you see, like this court cannot go into all those questions.
Yes,
In a
that
Jimai.
is- that's a matter of trial.
Submitting that the
And
offer
the-
was made in an electronic platform.
There are there are many pronouncements that vehicle should be normally, if there is more than one claim, it should be normally released to registered owner. That is what the law is.
Yes.
That is the
So that is what.
I'm going for clause 2, my lord. After 1 week, I'll come, sir.
Yes. Just say after 2 weeks on the prayer of the petition. Yes.
18.
After 2 weeks.
Obviously.